in Morgan County Correctional Complex is freezing. He is simply freezing. He told me in a letter yesterday that I will be citing in a letter to the Department of Correction, and Alyssa Taylor, the spokeswoman who says that everything he says is fictitious, right? She says that he cannot be relied upon. Everything he says is fiction. This, of course, is baloney, but that is what she says. And yet I'm going to send her the substance of his letter. Though I'm behind, I get more correspondence from Brenda Harmer than I can deal with. And I have now 2 other correspondents in the state slave system. The Randy Stamps, who is the head of the Tennessee Government Employee Union or Government Employee Association, says that that's pretty harsh language to describe what we have in Tennessee. But we do have state slavery in Tennessee, and that's called the Department of Correction. It is an organization, a corporation that has a sunset provision in its charter, by the way, which is coming up for review and I'm supposed renewal in July. And no doubt it will survive the scrutiny of that terrible ordeal of facing the sunset. And that's because people in Tennessee want prisons. Though they are extra biblical, they have no warrant in godly virtue at all, and in fact they're anti-Christian. People in Tennessee view them as a neutral evil. It's not really wrong. It's not against God's word. God doesn't forbid them, and so they have no idea often what the scriptures say about important things like whether we should have prisons or not. And the scriptures say no. The scriptures do not have punishment of that kind in view at all. The prison system comes from the Quakers, who gave 2 contradictory elements in American history. One is the abolition movement against slavery, and the other is the prison system, which establishes slavery on the state end. Right, prisons are state slave institutions, and in fact, in the Tennessee Constitution, in the Bill of Rights, you have exactly that. Chattel slavery is forbidden, but state slavery is allowed for one who is duly convicted. So you shifted slavery out of private hands into state hands. Robert Whipple says, I continue to be denied physical access to a law library here at BCCX. Oh, I was mentioning Brenda Harmer. In his 60s, Brenda Ray is his name. He's freezing at the end cell in Unit 1, though the air conditioner seems to be running, and he was wear every piece of clothing. He had triple socks, triple T-shirts, jacket, coat over that, triple pants, all the underwear he has. He's wearing it, and he's freezing in his cell at the end of the block. And he says that he's being treated that way because he is my correspondent. And he is also the correspondent of Sharon Rondeau, who runs the Post and Email in Connecticut, the website. For anybody who cares about prisons in Tennessee, she has become the real source of content and information out of that series of hellholes, some run for profit by CoreCivic. So Brenda Harmer is freezing, and he's pleading for help. Now, Robert Whipple has a different problem. One is access to the law library. In fact, he says it has grown worse. We used to be able to request legal material, and if the request was approved and you had provided the exact case citation, right, if you have one letter wrong, it won't come through. They'd send you a copy of the case. Sometime in October, the law library just stopped responding to these requests. I have filed a supplemental complaint in Whipple versus Tennessee Board of Parole, which has not been addressed or screened by the court yet. I was able to speak to an Assistant Attorney General, Amanda Jordan, by phone recently and offered to drop one of my pending lawsuits if the state would provide BCCX Annex, he's in Pikeville, inmates with law library access. Now, the other matter for Robert Whipple that I want to describe for you in this state slavery, right? We have state slavery, which just remember, if you've been enslaved by the state, you can't make restitution, right? Restitution is the main theory of the Bible, and God's jurisprudence is all victims' rights centered, right? American jurisprudence, being humanistic, is state centered. The resolution is the state, the punishment is the state, and the victim Well, don't worry about the victim. We'll let him take care of himself. And so there's no effort to have any restitution at all, though it is in the miscellaneous, the right of restitution from your offender, right, from the person who committed a crime against you, is in the Constitution. It is not enforced. But my question is, why do we have laws that are often ignored here in Hamilton County? As we will see, Tom Greenholtz, Don Poole, Barry Steelman, Lila Statham, and Gary Starnes are judges, and they readily ignore. They ignore an important provision in Title 39, which is the requirement for culpable mental state. But here now we're hearing about a man who's got questions about his health, and he says in a complaint to Dr. Belknap on the official stationery of the Department of Correction, "I have not received my shoes. Can you check on them?" he asks. So then he explains more about his problem. It's a grievance, and the grievance in a nutshell is that administrative necessity is obviating or blocking a medical prescription, and the prescription is for shoes. And here he's explaining on page 2 of 3, inmate grievance. He says, "I've been borderline diabetic for several years. At my last chronic care visit on 10/25/17, Dr. Belknap diagnosed me with diabetes. He also diagnosed me with diabetic neuropathy. This is a painful condition which makes it difficult to walk, which has led me to stop walking for exercise, which in turn caused significant weight gain. TDOC boots issued pursuant to policy 504, etc., exacerbate this condition. The boots are poorly made and are not available in wide width. My feet are unusually wide, and I require a wide shoe. Union Supply offers very few wide shoes, which are usually out of stock. Given all this and my need for a well-fitting shoe to alleviate the pain of diabetic neuropathy, Dr. Belknap prescribed for me a pair of diabetic, quote unquote, diabetic shoes. Dr. Belknap told me it would take about 2 weeks to get them based on Dr. Belknap's prescription. I told my family not to try to order shoes during the November package month." So apparently you can get one package a month. And he told his family, the Whipple family, don't get shoes from me. Don't bother. They're going to be coming from the system. When I didn't get the shoes in 2 weeks, I wrote an info request attached to Dr. Belknap on 11/9/2017. Phyllis Sutton intercepted my request and said she'd check on the shoes, but never heard any more. I then spoke with Nurse Dara on November 22nd, who told me that it was the policy of Centurion, the medical provider, and Health Services Administrator Kathy Campbell to only provide diabetic shoes to insulin-dependent diabetics. This policy was put in place to save money by reducing patient care. Mrs. Campbell and Centurion are not doctors and should not override my physician's medical order for shoes, he says. And turning the page, and then he cites a policy which states that when deemed necessary by the attending healthcare provider, durable medical equipment shall be provided. This policy does not depend, he says, on the whims or desires of Centurion or Mrs. Campbell, but only upon what is deemed medically necessary. Federal law prohibits exactly this sort of interference with medical judgment, finding that prison officials violate the Eighth Amendment when they interfere with prescribed treatment. See Estelle versus Gamble. Well, that's not a law being violated, but that's a policy. And it seems unjust to this state slave, Robert Z. Whipple, who was mentioned, by the way, last week on the jump page of a Times Free Press page 1 story about the audit of the prison system that showed grievous administrative problems. Right, administrative problems are not necessarily evils; they're just lack of accountability, lack of being able to show that you had the right number of people, that you had a safe minimum staff requirement, and so on to oversee these state slaves. But there are many laws that are simply ignored or activity by the state which is simply created from nothing. In other words, it originates without authority. It originates ex nihilo, which is Latin from nothing. Ex nihilo, nihilism is sort of the belief in nothing, right? So nihilism, nihilo, the same word there in Latin. And so activity done ex nihilo has no authority, and yet it's done as a matter of practice. And then it becomes routine, and then it becomes policy. That's how things work. And we can't, in the end, we can't see it anymore. We can't see it as evil, and we can't see it as wrong or lawless, right? It's not lawless because important, good people are doing this thing that is not authorized, or doing this thing which is perhaps is forbidden, right? It's simply forbidden. Like in the court system, I'm willing to bet there are many shortcuts that are taken that damage the rights of the state victims, who are the defendants in these cases, right? The city and the county are constantly creating defendants, people accused by the Fellowship of the Finger of crimes. The Fellowship of the Finger, Neil Pinkston, the district attorney, and who lets cops get away with crimes, by the way. He lets them get away with crimes. And then the other part of that fellowship is the officer. They work together to fill the jail. And in the jail downtown, there are 66% of the people who are behind bars right now. According to Matt Lee in a recent email to me, that's 318 are pretrials, and in Silverdale, nearly 40% of the people are there not having been convicted of any crime. That's 359 souls, men and women, 359 souls at Silverdale, not convicted of any crime, and yet there they languish because they can't make the bail. And there is a problem in the cash bail system. It is corrupt, it is evil, and it prevents these people from making a defense, and their lives are ruined. If you are living on the margin and you can't afford to pay a bondsman $100 for a $1,000 bail, you can't pay the fee. Your life is in ruins. Okay, you have tenuous connections already with your landlord, with the utility company. You're behind on that. With your employer, you're behind there. With relations, you owe money to your uncle, to your father. You can't pay it back. You are in distress, and getting caught in the state dragnet for some paper offense is really all you need. And you have no hope. You simply have no hope anymore. Now, one way I think of solving our problems is for the judges, whom I've named. Right, you know these names: Tom Greenholz, Don Poole, Barry Steelman, Lila Statham, and Gary Starnes. You need to ask them, what about mens rea? Now, that's just Latin for a rule, and that rule is called culpable mental state. There is a requirement that the prosecutor, that the cop, and that the judge respect the law and not deal with anybody charged with a crime unless they're prepared to argue for and adjudicate over a claim that person intended to violate the law. And that's required. It has to be part of the charge. It has to be part of the proof in a case. And no judge should allow any prosecutor or any assistant DA to prosecute a case without dealing with this point. We can solve today. We can solve in Hamilton County, Tennessee, and in these outlying counties who are tuning into my program. If you happen to be one of those, I do welcome you. And we can end the jail crisis, which is a shameful thing. The jail crisis where we have people who can't afford to make the bail, who are local people, right? They have local family. They can't make the bail, and so they're behind bars. They can't make it. And there's no interest in proving against them that they were having in their alleged crime, a culpable mental state, which is what's required. A person commits an offense who acts intentionally, knowingly, recklessly, or with criminal negligence, as the definition of the offense requires, with respect to each element of the offense. So if there's an offense, each element of it has to be proven that they intended knowingly, recklessly, or intentionally, or with criminal negligence to effect that wrong under that law. They had to know what the law, if the law forbade it, they had to know that. And that has to be proven by Neil Pinkston. Pinkston has to prove, at least he has to argue, that person knowingly did it. And that's called the mens rea principle. A culpable mental state is required within this title unless the definition of a defense plainly dispenses with the mental element. That's called a strict liability crime, and state law has only a few of those. In the definitions, intentional refers to a person who acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective. Okay, got that? The person's conscious objective to engage in the conduct or cause the result. Knowing refers to a person who acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct that it's illegal, right? He has to know that the conduct is illegal, right? And that he did that conduct knowing that it was illegal, right? Or that the circumstances exist. A person acts knowingly, the law says, with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. And so there has to be in the concept of criminal negligence the idea of a gross deviation from the standard of the ordinary person. Again, there has to be an argument made that the person knew that this conduct was wrong, and he intended at every part of the crime to do that wrong thing. And there's a difference between motive and intent. Just think for a second about that. Now, you can do something with a motive, but that's not intent. The dictionary says that intent is the inducement to do some act, right? Because your motive is why you did it, what went on in your mind to prompt you to do a certain thing. Intent, though, is different. Intent is the mental resolution or determination to do it. When the intent to do an act that violates the law exists, motive becomes immaterial. So in other words, you don't have to prove motive. You can see motive, but you don't have to prove it. What you have to prove is intent. That has to be argued, and it has to be proven. Criminal intent, mens rea, is an intent to commit an act without a criminal act without any justification, excuse, or other defense. And that's that law now. This law, which comes from the Bible, is ignored in our courts. It's ignored by the prosecutor. And if the Christian ministers in this city, if Christian ministers would say, I know where that law comes from. It comes from Deuteronomy 4, and it comes, which is a repeat, and also from Deuteronomy 19, which is the mens rea statute. And that is about, it's in the discussion reported by Moses of God, talking about the two woodsmen, right? And the one who kills his neighbor unintentionally, right, not having hated him in time past, can flee to the city of refuge and can live. He's protected in the city of refuge. And now, what is an unintentional act? Well, Deuteronomy 19:5 says, as when a man goes to the woods with his neighbor to cut timber, and his hand swings a stroke with the axe to cut down the tree, and the head slips from the handle and strikes his neighbor so that he dies, he shall flee to one of these cities and live, lest the avenger of blood, while his anger is hot, pursue the manslayer and overtake him because the way is long, and kill him though he was not deserving of death, since he had not hated the victim in times past. So the mens rea rule says that if there's not intent to kill, it's a mishap, right? It's an accident. At best, it's manslaughter, and there can be compensation made for it. There can be paid a sum or a service rendered in exchange for, in compensation for, the death of that person. Of course, that's paid to the survivors. Intent is design, resolve, or determination with which a person acts. It is a state of mind rarely susceptible to direct proof, but must ordinarily be inferred from the facts. Intent presupposes knowledge. Okay, so there are many crimes which charges are made, which there is no presupposition of knowledge. And again, intent and motive are different. And so the prosecutor, Neil Pinkston, here in Hamilton County, has to prove intent on every crime. Every crime has to be proven intent. Well, what does that say about crimes of neglect, like failure to show up for court? That's not, how can that be a crime when someone had a problem with a schedule, right? Your car broke down. Poor people have cars that don't work very well, right? And the engine light goes on, suddenly there's a clanking sound, and the car doesn't work. How are you going to get to court? How does that happen? Well, these are the kinds of things that cause people to offend their master in the court system, and they're charged with crimes. Now, intent, if properly argued, if we insist on intent being argued, we would have a reduction in copdom. Cops would not be prosecuting people as much. You could have reduction as much as 85, 90% of prosecutions in Hamilton County. Only people whom the officer, if he's the witness, can say showed intent. Only when he has some sense of what the intent is should he prosecute. Now, what I'm suggesting here would require some training in the law of the officers. Rather than 150 hours of how to kill people, how to beat people up, how to dodge their blows and so on. Defensive tactics, offensive tactics, rather less that and more respect for the law and more respect for the individual. No more massacres, right? No more Javario Eagle execution. Javario Eagle was having a mental episode. Clearly, he did not need to be ganged up upon by 7 or 8 cop cars with 15 officers. That did not have to happen. Shot down with 17 or 18 bullets in the second fusillade. And then, of course, he was handcuffed as he was lying on the ground to secure the subject, right? That's what has to happen. This is David Tulis. I'm calling for mercy. I'm calling for grace in Chattanooga and an end to the sort of militarization of law enforcement and lenity. David Tulis.
Traffic, news, and information. Nooga Radio. Digital FM 95.3.